Well, there's nothing there that they don't know.
Did you see the offer?
Before a single ruling is made, let's set the stage, because this is not just another courtroom appearance. This case opens with a third-degree felony allegation that immediately grabs attention: assault of a pregnant person. That charge alone signals seriousness, but what follows makes it even heavier. We're dealing with allegations of choking, flight from police, and a judge who is clearly drawing a hard line from the very start. The tone here is firm, almost instructional, and that's intentional. This court is making sure everyone understands the stakes before emotions or negotiations muddy the water. Watch closely how the judge frames responsibility, protection of the victim, and accountability. And ask yourself as this unfolds, when a case starts this strong, does the defendant have any real room to maneuver, or is damage control already the goal?
Do you understand you cannot have any contact with this person? You do, you will be in jail. It'll be so fast. If I find out you've contacted her or someone on your behalf contacted her, until we can resolve this, you will sit in jail. So they advised that David Scott was detained at the back of a patrol car due to him running away on foot. Guilty men flee when no man pursueth, but the righteous stand bold as a lion. You know where that's from?
No.
Proverbs, the holy book. Proverbs. I then made contact with other officers at the scene who advised me it was discovered Scott had a verbal altercation with his pregnant girlfriend, which escalated to a physical altercation. He began to assault her. During the assault, Scott forcibly placed his hand on her throat, impeding her breathing. The victim wished to file charges, and she had visible injury to her body. I believe and do believe that Scott intentionally, knowingly, or recklessly impeded the normal breathing or circulation of the blood of the victim by applying pressure to her throat to prevent further acts of family violence. I place him under arrest. And he was transported to the Jefferson County Jail. Well, that's a terrible.
This is the moment where allegations turn from abstract to alarming. The court isn't speculating, it's laying out the elements: choking, impeded breathing, visible injuries, and a pregnant victim. Under Texas law, that detail alone dramatically elevates the seriousness of the charge. This isn't just assault, it's assault with enhanced vulnerability. The judge's language here matters. He's emphasizing protection, zero tolerance for contact, and immediate consequences if boundaries are crossed. Notice how fast no contact turns into you will sit in jail. That's not rhetoric, that's enforcement. And when the judge references influence or interference with the victim, he's signaling awareness of how fragile these situations can be. So here's the question for viewers. When courts move this aggressively, is it about punishment or prevention?
We're here at 2 a.m. and deal with this quickly.
Yes, sir.
But
Charlton.
I don't want this person being influenced illegally. What are you going to do today?
Set for trial, Your Honor. I've talked to my client several times, and we want to use.
Have you talked to the victim at all?
There was a note
You didn't
Judge,
talk?
that the prosecutor before me had already talked to her, and
Why don't you do that?
Yes, sir.
I sense, I've done this long enough. I'm sensing a whiff in the wind. All right, it'll be set for trial. So today, it says other hearing.
No,
What
it's
does
not.
that mean?
No, it's no other hearing. I had reached agreement with Daniel to refile this as a misdemeanor. And Daniel did talk to the.
What is it? What are you filing? What's it going to be?
It's to allow a plea to misdemeanor assault, which doesn't require a refile judge.
Yeah, we
Because
can
of
do
the
it
nature
here.
of this offense, it
I
could
think
be done.
it's a
with-
lesser included class A, probably.
We talked
Yes, sir.
about refills, what I talked to Daniel about.
I'd rather do it here. I mean,
Let
get
me
it
double
done.
check the elements here, Judge.
It's an
Because,
aggravated, commit the felony aggravated assault.
yeah, we can certainly do it as a
So
lesser
assault,
included offense.
lesser included class A misdemeanor.
Yes, sir.
But then that would put her on the felony,
What?
like community service and like misdemeanor community service.
I don't know.
You know,
What they
we
do.
that's like 60 hours. I don't want to have a felony time. That's why I was going to refile it as a
Wait a
misdemeanor.
minute.
Not
Wait.
time, but you know what I mean.
That's
That's what's a
right.
condition.
It's clear that these notes say that the agreement is to do a class A misdemeanor assault, 2 years deferred, no fine. And not to
Well,
argue
okay,
with
yeah,
Mr.
yeah.
Adams,
Yes.
this can be done with as a lesser included
Yeah,
offense.
let me, the probation office, is there a difference between what they do in misdemeanor versus in felony on what, community service?
Yeah, because normally misdemeanor.
Hold on.
I'm sorry.
But on community service, but if it's a misdemeanor, wouldn't we treat it as a misdemeanor? It would be treated just as it would be a misdemeanor. And if you have a problem with it, let me know and we'll modify it.
Well, then if you wouldn't mind, just because normally in misdemeanor court and Mr. Ham used to. work
I'd rather
with
stay
courts.
it. I'd rather keep it here.
The community
Dispose
service,
it here.
that's fine, but the community service is normally like 40 to 60 hours.
Once
I
again-
don't want to get hit with
once
200
again,
hours of
I
felony
know.
stuff.
Once again, I reduce,
It's 80.
but I'm reducing it in a third all the time, and people still have a ton of that left, and I dispose of it and dismiss it if they've done well, and we can accommodate this here, just
That's
what
fine.
you want, that coincides with what the probation office does for normal Class A misdemeanors.
I can sign it up with that.
Thank you.
And then I'm gonna put in about 80 hours.
Sure. Well, whatever it is, it's going to be whatever that's normal and
For
customary.
misdemeanor.
Yes, I don't know why it would be. This is the first time, I've done this for 20 years. This is the first time I've heard when we reduce it, it's treated like it's a felony versus what would normally be a misdemeanor. I've never heard that. Really. I would have thought that's odd. I would have said something, but I've not heard that. And she's saying that's not the way it is.
So you good?
Okay.
This is where strategy quietly replaces outrage. What started as a disturbing felony allegation now enters negotiation territory. And this is where many viewers get confused. Let's break it down. The court is discussing a lesser included offense, meaning the underlying conduct can legally support a lower charge without dismissing the facts entirely. This is not the court saying the behavior didn't happen. It's the system balancing proof, victim cooperation, future compliance, and proportional punishment. Deferred adjudication becomes the key word here. It's conditional mercy. Follow the rules, complete probation, and the case goes away. Fail, and the consequences snap back fast. The judge's back and forth on community service hours isn't trivial. It shows how granular these deals get. So ask yourself, is this accountability done right, or a risky second chance?
In summary, this indictment alleges that on or about April 2nd, 2025 in Jefferson County, Texas, you committed the first degree felony of burglary of a habitation. Do you understand what you're charged with here?
Yes.
And there is an agreement that's been reached, and this states in the indictment burglary of a habitation with the intent to commit the felony offense of aggravated assault with a deadly weapon. An agreement has been reached that the defendant would be pleading guilty to the lesser included Class A misdemeanor of assault.
Yes, sir.
A person commits an offense of assault if the person intentionally, knowingly, or recklessly causes a bodily injury to another, or intentionally or knowingly threatens another with imminent bodily injury, or intentionally or knowingly causes physical contact with another that the person knows or should reasonably believe that other person receiving the contact would regard it as offensive or provocative. An offense is a Class A misdemeanor, except it is a felony of the third degree if other portions of elements of the crime are committed in addition. So here, everyone agrees that her actions in this lesser included Class A misdemeanor fit either subpart A, 1, 2, or 3 of section 22.01 of the Texas Penal Code, assault, Class A misdemeanor. Correct.
Yes, Your Honor.
All right. So you're looking at up to 1 year in the county jail and or a fine of up to $4,000 can be assessed. Do you understand the punishment range, ma'am? Yes?
Yeah.
Okay, an agreement's been reached where you would be pleading guilty here and placed on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You do well, and this case will be dismissed. If you fail, your probation could be revoked, and you could then be found guilty by the court and sentenced up to 1 year in the county jail. Do you understand?
Yes.
How do you plead to this, guilty or not guilty to this Class A misdemeanor?
Yes.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty of this Class A misdemeanor of assault?
Yeah.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states you mentally competent to enter your guilty plea, which is being done freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You were guilty of the crime charged and any lesser included offenses, such as this Class A misdemeanor. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer, Mr. Adams. All of this is true, so help you God. State's Exhibit 1.
No
Or your
objection.
record. Without objection, admitted. Pre-sentence report waived.
Yes, sir.
I'm going to follow this agreement. If nothing further, I'm going to find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any finding of guilt so long as you follow the terms and conditions of probation. The probation officer is going to go over with you, which is normal and customary for this type of offense. Make sure you understand it, follow it, and at the conclusion, do well. The case is dismissed.
Oh.
Okay, if you fail, we don't want to talk about it except to know that it could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. You don't want that. Anything else to add?
That's it.
All right, then see the probation office. Good luck. Thank you.
Thank you. Thank you.
Thanks, Langston. See you, bro.
All right. All right. Thank you, Judge.
This is where strategy quietly replaces outrage. What started as a disturbing felony allegation now enters negotiation territory. And this is where many viewers get confused. Let's break it down. The court is discussing a lesser included offense, meaning the underlying conduct can legally support a lower charge without dismissing the facts entirely. This is not the court saying the behavior didn't happen. It's the system balancing proof, victim cooperation, future compliance, and proportional punishment. Deferred adjudication becomes the key word here. It's conditional mercy. Follow the rules, complete probation, and the case goes away. Fail, and the consequences snap back fast. The judge's back and forth on community service hours isn't trivial. It shows how granular these deals get. So ask yourself, is this accountability done right, or a risky second chance?